Please help me welcome Tristan Leavitt.
In the fall of 1975, the Church Committee shocked the American public with public hearings that exposed widespread abuses by the CIA, the NSA, the FBI, and the IRS. The committee's biggest legislative legacy was the Foreign Intelligence Surveillance Act of 1978, the renewal of part of which has been discussed today, as it's coming up in Congress. But the FISA Act only referenced a portion of the many abuses that the Church Committee identified. So, for example, one section of the committee's 1976 report could easily have been written in 2013. It said, the IRS began comprehensive investigation of right-wing groups. This effort was directed at identifying contributions and ascertaining whether the organizations were entitled to their tax-exempt status. The fact that history has repeated itself on this issue should remind all of us that no law or policy, however perfectly drafted, is alone sufficient to stop government abuses. If the government shortcuts a process or takes advantage of legal ambiguities or just flat out disregards a law, how would the public ever know about it? The recognition of a need for widespread safeguards and greater government transparency contributed to the 1978 passage of the Inspector General Act and the Civil Service Reform Act, less than 2 weeks before the FISA Act. The Inspector General system, which Chairman Chaffetz just referenced, is actually how the public learned in 2013 about the IRS targeting conservative groups. Meanwhile, part of the Civil Service Reform Act, which is later known for the Whistleblower Protection Act of 1989 that amended it, established the modern whistleblower protections that most federal civilian agencies have. Its protections were created to ensure that patriotic federal employees would be willing to bring to light waste and fraud and illegal activity and the sort of abuses that were detailed in the Church report. Now, given how extensively the federal government's operations today touch every single American, there's a greater need for transparency now than any other time in American history. So, too, is the need to protect those with inside information who have the courage to speak up about abuses they see. The Civil Service Reform Act established a process for vindicating whistleblower protections through the Office of Special Counsel, or OSC, and the Merit Systems Protection Board, MSPB. Having led both agencies, I can say that while the process isn't perfect, it can play a very important role in protecting those who speak truth to power. Let me give you just one example. In early 2011, during the Obama-Biden administration, Senator Grassley hired me to help conduct investigations into federal law enforcement abuses. I was immediately thrust into the battle between the massive Department of Justice, which we've discussed a lot today, and one single ATF agent, John Dodson. John disclosed to our office a gun-walking case called Operation Fast and Furious. In it, the Arizona U.S. Attorney's Office and Phoenix ATF had allowed nearly 2,500 semi-automatic firearms, mostly AKs, to be trafficked to Mexican drug cartels. Guns from that case were recovered at the scene of a shootout near the Mexican border that resulted in the death of a Border Patrol agent, Brian Terry. When that happened, John Dodson felt he had no choice but to go and blow the whistle. And so he went to Senator Grassley's office. Senator Grassley wrote to DOJ, citing a whistleblower with evidence and asking for an explanation. Now, you'd think that having cited that he had a whistleblower with evidence, DOJ would have been more careful at that point, but instead, they wrote back denying the truth. As then ATF Supervisor Peter Forcelli recounts in his new book called The Deadly Path, trouble was brewing behind the scenes, though, because of that letter. The U.S. Attorney's Office in Phoenix went to ATF and said maybe they should indict John Dodson. Agent Forcelli heard this and then blew the whistle to Congress on DOJ and ATF's plan to retaliate against John. Then DOJ came after Agent Forcelli, accusing him of perjury after he testified to Congress. Fortunately, facts are stubborn things, as John Adams once said. Thanks to those courageous whistleblowers and the evidence that they brought forward, the world learned the truth about Operation Fast and Furious. DOJ eventually had to retract its false letter to Senator Grassley. It did refuse to turn over documents about its initial misleading and retaliatory response, and so in a bipartisan vote, Attorney General Eric Holder became the first sitting Attorney General to ever be held in contempt of Congress. But throughout that entire battle, we continually reminded ATF and DOJ that it would be illegal to retaliate against the ATF agents who had come to us. That said, just like Jason talked earlier about the inability to enforce subpoenas, the reality is if any of the whistleblowers had been fired, we in Congress would not have had any legal authority to put them back in their jobs. That's why we needed OSC. OSC eventually helped both agents Dodson and Forcelli to reach settlement agreements with ATF. Both of them served out the rest of their law enforcement careers. Each of them retired within just the last 2 years. I don't think that would have happened without OSC. But not all federal employees have the kinds of protections that agents Forcelli and Dodson benefited from. As I testified nearly a year ago before the House Weaponization Subcommittee, FBI whistleblowers are treated differently than those at every other federal law enforcement agency. Now, this special treatment is frankly baffling in light of the FBI's history, especially that revealed by the Church Committee. But even after that, the FBI still had immense clout. So when the Civil Service Reform Act approached final passage in 1978, the FBI convinced Congress to give it a special exemption. On paper, whistleblower retaliation is prohibited at the FBI. But instead of OSC and MSPB investigating and adjudicating FBI retaliation, a carve-out allows DOJ to do it instead. They just keep it in the family. This lack of independent oversight gives FBI whistleblowers second-class status. And of course, DOJ took advantage of the FBI's exception to add additional rules and roadblocks, such as only protecting whistleblower disclosures to the Inspector General or to the head of each FBI office. In the mid-2010s, I worked with Senator Grassley and with Chairman Chaffetz to try and change that. We obtained report after report that showed how flawed the FBI whistleblower protection process is, and we introduced a 2016 bill that would have made some basic improvements. It was blocked by one particular committee in the House of Representatives. I negotiated with that committee extensively to overcome their objections to treating the FBI the same as other law enforcement agencies. In the end, we were only able to get one change in a rump bill, adding supervisors to the list of protected whistleblower disclosure recipients. At the time, many members of Congress didn't seem to believe the modern FBI was capable of widespread abuses. How times have changed. As you've heard today from multiple speakers, over the last 8 years, the FBI has gotten one black eye after another. Every year seems to turn up a new major scandal involving the Bureau. I still know a number of very good men and women in the FBI, and I'm sure there are countless more. But it's precisely to empower those who take their oath to the Constitution seriously that the FBI needs stronger whistleblower protections. Given all that we've seen from the FBI since 2016, I wonder if that House committee regrets blocking our bill. Thanks to efforts by Mike Howell here at the Heritage Foundation, the NDAA for fiscal year 2023 finally gave FBI whistleblowers the right to appeal to MSPB. For the first time, an agency outside of DOJ chain of command has the authority to force the FBI to make whistleblowers whole. But Congress can't stop there. There's no reason for the FBI to be the only agency whose employees can't go to OSC. OSC has the expertise and the litigating authority to present cases before MSPB, which is the main reason the agencies decide to settle those. Given those abuses, FBI whistleblowers need this protection now more than ever. Even if Congress were to eliminate the FBI's special treatment in the law, the FBI has been retaliating in ways that OSC and MSPB can't correct. In the 1988 decision Navy versus Egan, the Supreme Court considered whether MSPB could review removals on security clearance decisions. The court held this wasn't within MSPB's statutory jurisdiction. And since then, several laws have tried to fix this to stop agencies from using clearances to retaliate against whistleblowers. But again, without OSC investigating, they have little recourse. It's become clear in recent years how ripe this is for abuse. When you heard from Special Agent Steve Friend and Garrett O'Boyle, both of whom Empower Oversight tried to help, they had their security clearances suspended for doing the right thing. Another client of ours, staff operations specialist Marcus Allen, emailed his chain of command to make clear that even though FBI Director Chris Wray had testified to Congress and given the impression that there were no FBI informants at the Capitol on January 6th, the New York Times had reported that there were indeed many informants of the FBI present on January 6th. For making that disclosure, the FBI suspended Mr. Allen's security clearance, and 2 years later, we are still fighting to try and get it back. There is a bill currently pending in the House, H.R. 7750, which would allow FBI employees to have those clearances looked at by the DOJ Inspector General. But this, again, is just one small step forward. Ultimately, Congress needs to overturn Navy versus Egan. Let me come to the topic that people are most interested in right now. Just like we saw in Fast and Furious, the final sign of desperation is to accuse whistleblowers of breaking the law. Last April, we at Empower Oversight assisted IRS Supervisor Gary Shapley in disclosing to Congress how the Hunter Biden investigation had been politicized within DOJ. Agent Shapley and Case Agent Joseph Ziegler disclosed that the IRS and the Delaware U.S. Attorney's Office had approved felony tax charges against Hunter Biden because of the income that he made from Burisma in Ukraine, but then tried to hide. And yet, nevertheless, U.S. Attorney for Delaware, David Weiss, allowed the statute of limitations on that to expire. But almost immediately after we went to Congress, Hunter Biden's attorneys started lobbying DOJ behind the scenes to prosecute Special Agents Shapley and Ziegler. They falsely claimed that they violated grand jury secrecy, again, that playbook from Fast and Furious, and the taxpayer privacy laws. Hunter Biden also filed a lawsuit against the IRS, identifying myself and my co-counsel and saying that these agents had violated the taxpayer laws. Now, normally that would be defended against by the government because it's a lawsuit against the IRS. But the attorneys that were assigned by DOJ to defend against that case come from one of the very offices that the IRS whistleblowers identified, the DOJ Tax Division, as spiking the Hunter Biden case. That's a clear conflict of interest. Those attorneys haven't made clear to the court that the law protects the right of whistleblowers to share this tax information with the proper entities in Congress. On another legal front, Special Counsel Weiss recently disclosed in California federal court the existence of a potential investigation into Agents Shapley and Ziegler. If such an investigation exists, it can only be viewed as retaliation. But either way, David Weiss shouldn't even be aware of such an investigation, much less telling the public about it. The IRS whistleblowers' disclosures to Congress were all about the mismanagement of Weiss's own office. He's also the subject of a retaliation complaint we helped to file with OSC. Ironically, even as Weiss is bringing criminal charges against Hunter Biden, his interests align with Biden on one thing: attacking the IRS whistleblowers. Last Thursday, we sent a 20-page letter to Merrick Garland asking him to fix this. But this retaliation can't be allowed to stand against these brave IRS whistleblowers, or why would anyone else come forward in the future? Now, it's important to recognize that that same question applies to all cases of whistleblower retaliation. As conservatives, we believe in equal treatment under the law. Intellectual honesty requires that we prohibit retaliation evenly, regardless of whether you care for a particular whistleblower's point of view or specific disclosures, however big or small. But I wholeheartedly agree with what Chairman Chaffetz, Chairman Mark Meadows, and Senator Grassley wrote to the White House at the beginning of the Trump administration. Whistleblowers can be one of the most powerful allies to drain the swamp in Washington, D.C. By speaking truth to power, these patriots risk their jobs, their reputations, and even their health and well-being. So it's critical that we protect them. To do otherwise would dishonor everything that we stand for as a nation. Thank you.